Hello guys, this is Olayemi Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we are talking about the utilitarian theory of law. In past episodes, we discussed the natural theory of law as well as the positivist theory of law, positivism as you might call it, and the two types, which is the Hans-Kelsen pure theory of law and the John Austin command theory. In today's class, we are going to be talking about the third theory, which is the utilitarian theory of law. If this is your first time, however, of coming to my channel, then I want to say a very big welcome. Thank you so much for coming to my channel. Please make sure that you click the subscribe button as well as the notification bell, so that anytime I release a video like this one, which is going to be of interest to you, you are going to be one of the first set of people to watch that particular video. Also, make sure that you follow me on LinkedIn at Dieko Daniels. Thank you so much as you do so. So today, like I said earlier, we will be talking about the utilitarian theory of law. And before we go straight into the lecture, let's look at an overview of our lecture. This lecture will be divided into part A, B, and C, which tells us that there are three parts. The first part, which is part A, this particular lecture, we will be talking about the meaning of the utilitarian school of law, or theory of law as you may like to call it. We'll be talking about the philosophers of utilitarian school of law or theory, and the examples of laws with influence of utilitarian school. Now, the part B, we will be talking about cases of utilitarian school of law, while the part C will be talking about the criticism of the utilitarian school of law. So let's go straight to what we have in stock for today. I'm very sure you are excited to learn. So going straight into the meaning of utilitarian school of law or theory of law. Now, the utilitarian theory of law or utility theory of law was started by a man known as Jeremy Bentham. It is very quintessential. Quintessential also means important. Very quintessential that you have that name at the back of your head. Always and always. The person who started the utilitarian theory is Jeremy Bentham. He is an English philosopher, economist, and legal theorist. He propounded that, number one, that life is full of pain and pleasure, and the law should be a tool of social engineering or means to increase human happiness and minimize pain. Also, he said that the law should be enacted to secure or ensure the happiness of the greatest possible number of people. The aim of the law should be to minimize human happiness by securing the greatest happiness of the greatest number of people. Now, Jeremy Bentham rejected natural law as nonsense and described it as nonsense upon stilts. Now, before we go a little bit further with what we have said so far, what is Jeremy Bentham telling us? Jeremy Bentham is coming from a very unique perspective, very unique and different. When we look at natural law, they told us, see, when you are looking at the law, you are looking at whether it is fair or just. If it is not fair, if it's not just, if it's not right, strike it down and do not obey it. And then when we go to the pure theory or we go to the command theory, they tell us law is what it is. Have they made it to be law? Is it valid? Can we relate it or follow it through and find the ground norm? Does the ground norm give this law a validity? The moment we can find the validity from the ground norm or the uncommanded commander, as the case may be, then trust me, ladies and gentlemen, there we have our law. And then Jeremy Bentham looked at the positivist. He said, no, I don't like this idea. He looked at the naturalist. He said, wow, this is nonsense. And according to his own words, this is nonsense upon stilts. I am going to give you something very different and unique And then he came up with the Utilitarian school of law, and then he told us that for you to have a valid law, then that law must derive happiness from the greatest number of people. The moment we have a law that the majority of people in a community can say yes to, can tell us that they are happy about, then we've had a valid law. That is the formula according to Jeremy Bentham. When you look at natural law, Jeremy Bentham says that is nonsense. Nonsense upon stilts. When you look at positive law, Jeremy Bentham says no, you cannot follow that. We have to look at the greatest number of people who are happy. Now, to continue with the note, Jeremy Bentham also said that all existing laws and consequently the institution established by such laws should be reformed to secure the greatest happiness possible for the populace. Also, that whether any law was good or bad should be decided by measuring or evaluating its utility to the individuals and the society. So you see, I'm going to try to put this in context of Nigeria. Do not forget that at all times I always make sure that I remind you that in Nigeria we practice positive law. When you get to court, what the court will be looking at is whether that law has been validly made by the legislature. The court does not look at whether the greatest number of people are happy by virtue of the law or whether the law is fair and just, except the court wants to invoke its equitable jurisdiction in certain rare cases. But the court in itself will practice positivism. Is that law made validly? Can we trace that law to the ground norm? However, I want to put this a little bit in context of the Nigerian society, most importantly in context with the Sharia. Now, a lot of people, a lot of my friends, both Christians, Muslim, people from different tribes, we've had a discussion as to why the Sharia is still in existence in this 21st century. Why exactly do we have a law that authorizes people's hands to be amputated, to be cut short when they steal? Why exactly should we have a law that says that a girl should be buried body deep into the ground with only her neck out, and that girl should be stoned to death? Why exactly do we have that law that authorizes you to stone her head till the last life in her, last breath? Why do we have that law in the 21st century? When you come from the angle of the positivists, they will tell you so far the legislature passed the Sharia, then it is valid. But I don't want to come from the angle of the positivists. I want us to see the fight between the naturalist and the utilitarian. Now, when you look at the utilitarian, they tell you that for a law to be valid, let us look at it from the standpoint of that particular community where it is to be practiced. Now, when you look at the northerners and the fact that they follow the Quran hook, line and sinker, and the fact also that they have always practice the Sharia, if you decide to take the Sharia away from them, the question is, would majority, according to Jeremy Bentham, would majority be happy about this? Would this be the happiness of the greatest possible people? That is the question we would ask. And if we should ask that, we all already know what the answer is. They definitely would say no. They want the Sharia to continue. And this is where the war always comes between the natural law and the utilitarian law. Because in certain aspects, when you look at certain laws, those laws are not necessarily fair, just, or right. But because the certain number of people are happy, and those are the majority, by the fact that they are being governed by such kind of law, the naturalist would have to keep short. Do you understand that? Do you see why I say that we don't practice natural law in Nigeria? Because obviously if we did, the Sharia would not be in existence. Do you understand what I'm saying? If we did, the Sharia would not be in existence, except you have an alternate opinion in relation to that, which I'm definitely welcome. But it's my opinion that if natural law, what is fair, just and right and all that, is practiced in Nigeria, the Sharia is likely to be struck down. But because, coming from the utilitarian perspective, they are happy with the kind of laws that they have, then by all means they should have their laws. Do you understand that? So now let us continue with our notes. Now, number 6 tells us that there are 4 major utilities or good any and every society should seek to promote. And what are those? Number 1, security. Number 2, equality. Number 3, abundance. Number 4, liberty. So I made it very possible for you to be able to pronounce it. S-E-A-L. Seal. When you are talking about Jeremy Bentham, talking about utilitarian law, seal should always come to your head. There is no way you should enter any legal method exam or jurisprudence exam and not talk about the seal, the security, the equality, the abundance, and the liberty, which is in relation to utilitarianism. Telling us that when a law is to be made, we should not look at whether or not the law is fair or just. Instead, we should look at whether or not the law is for the greatest number of people in relation to these 4 major utilities: security, equality, abundance, and liberty. Also, the government, in making laws and policies to achieve these goals, these are the goals of utilitarianism: security, equality, abundance, and liberty. If we are to make laws and policies to achieve these goals or ideals, the government should weigh the interest of the individual as against that of the state, and should promote the interest of the state or the interest of the majority against the interest of the individual at all times. The majority should always trump the interest of the individual. That is what Jeremy Bentham is saying. The law should be something that when you are looking at, you should always come from the perspective of what will the majority say, what will the majority do. And at all times, if there is a conflict between an individual right and the state right should always trump that of the individual rights. Do you understand that? Now let's go to the philosophers of the utilitarian law. Now, the philosophers of the utilitarian theory include, number 1, David Hume. Now, he first propounded that utility be used as a substitute to natural law. However, he did not expand the proposition. Jeremy Bentham expanded the proposition, propounded, and led the utilitarian school of law. Number 2, Jeremy Bentham, his legal theories and writings influenced the subsequent reform, codification, consolidation of statutes, and abolishment of obsolete and arbitrary laws and provisions based on the criteria of reason and utility. He was an egalitarian and is generally regarded as the father of the English jurisprudence. And then lastly, John Stuart Mill. He was a faithful follower of Jeremy Bentham. He systematized and expanded the utilitarian theory of law and advanced the upliftment of women and the lower classes of the society. Now, at every point where you are going to talk about utilitarian law, always make sure you had David Hume. David Hume was the person who for the first time spoke about utility. Utility means what you enjoy the most. Do you understand? For example, if you are going to buy anything right now, you are buying it because you need it for something, and that something gives you happiness. For example, a lot of people love to buy the iPhone, not because the iPhone has a particular thing that differentiates it from every other phone, but because of one thing: the camera. The camera of the iPhone is very unique and different, and because of that, that is the greatest happiness of everybody using iPhone, at least for most people. Do you understand that? Now, when you're about to go and get an iPhone, you are overjoyed and happy that yes, I'm about to go and get what? A very good camera phone. Right? Now imagine that you got the camera phone, that's the iPhone, and then they told you that everything in this phone is working, only the camera is not working. How are you going to feel about that? Do you understand what I'm saying? Therefore, when a law is such that at the end of the day, you realize that what makes you happy about the law is not there, you strike it down. That is the utility. The utility from the iPhone is the camera. The utility from your food is your survival. The utility from everything that you do is getting something that you want. The utility of a law should be the happiness of the greater number of people. Do you understand that? The utility of the law should be the greater number of people, and not whether or not the law is fair. The law is that. We shouldn't look at that. We should look at the utility alone. Do you understand? And then we go lastly to the laws with influences of utilitarian theory of law, starting with the social welfare laws. We have the fundamental right chapter of the 1999 Constitution. We have pension laws, Child's Right Act, etc. So when we are looking at social welfare laws, for example, when we start with the fundamental human rights, I mean everybody wants fundamental human rights: right to life, right to movement, right to privacy, right to this, right to that. Those are laws that everybody would want. We are happy that that law exists. In the military system of government, they took away that law that guarantees fundamental human rights, which is the reason in the military system of government they could barbarically lock you up without food, without anything, and beat you up, and yet still go to court, and the court will say, well, apparently you have no fundamental human rights. Do you understand that? So when we have that in a democratic society, it is to the happiness of the what? Of the greater number of people. We also have the Land Use Act, including the acquisition of private land for public highways, public housing, and so on. So when a private person has a land, according to the Land Use Act, the government can decide to take away that land from that private person, although they are going to give the person compensation for that, in order to build things for public purposes, either build highway, or build public homes, or build a public hospital, or build a university, build anything that they want to, but it has to be for public purpose. So you can see that the interest of the greater number of people trumps the interest of just one person, that is the owner of the land. And then we go to number 3, derogation from fundamental rights in the interest of others and the state. Now, I told you that in number 1 example, we're talking about fundamental right, and I told you that everybody is happy that we have fundamental right. However, there are certain rights that are derogable rights. Those derogable rights are rights that where it clashes with the interest of the states. When I mean interest of the state, if you look at section 45 of the Constitution, we are talking about rights that is against public order, public morality. When you do something that is against public order, public morality, and all that, there can be a law promulgated to cut that your right short. For example, you would agree with me that everybody has a right to what? To movement, right? No problem. According to the Constitution, part of our fundamental human right is right to movement. However, during Corona period, nobody moved to anywhere for months, weeks at least. Nobody. We were all on lockdown. Why? Because there was a law that was promulgated. That's the Quarantine Act. The Quarantine Act empowered the president to make a regulation that would tell everybody to stay at home until we have public health back, because the public health was at stake. Do you understand? So in the event of that, we can have certain derogable rights where your rights would be restricted from what it used to be the general thing, and that we are putting the interest of the general public, the public health, the public safety, the public order over your own personal right to movement, or over your own personal right to privacy. For example, if they find out that Hush Puppy is a fraudster, is a this, yes, everybody has the right to privacy and should not be watched by the police either through their phones or followed through their laptops and all that. But where your act is seeming to be against the public, public order and public safety, then they can infringe that right for the advantage of the public. So the public is to always be number one priority. The society, the majority should always be of priority in relation to good laws, according to Jeremy Bentham. Do you understand that? And then lastly, we talk about free education, universal basic education, immunization programs, the national health insurance scheme. Those are just examples to help you understand how the whole utilitarian law theory works. Don't worry, in my next class I'm going to talk in details about the utilitarian part B, where I'll be talking about the cases, interrogating different cases in relation to utilitarian law. Thank you so much for watching to the end of my lecture. Please do not forget to click the subscribe button as well as the notification bell, so that anytime I release a video you definitely would receive it. Do not forget to also click the like button of this video, and also follow me on LinkedIn at Dieko. I will see you in my next class.